Welcome to the Deep Dive. Today we're jumping into a topic that affects a lot of people here in California and honestly can be pretty stressful. Evictions.
It really can.
It's a legal process, right?
Yeah.
With really specific rules. And, for tenants especially, figuring out these rules can feel overwhelming. If you've ever felt confused about your rights or what happens when a landlord asks you to move, well, you're definitely in good company.
Absolutely. It often feels like a maze, but there's a definite starting point to the whole eviction process in California, a really crucial one.
Right. And that's what we're zeroing in on today in this deep dive. The California Eviction Notice. That's the key phrase here.
Mm-hmm.
We've sifted through, court guides, tenant resources, legal summaries, trying to distill it all down for you.
Yeah, the goal is really to pull out the essentials, the most important bits, so you can feel informed without getting totally lost in the legal language.
Exactly. So whether you're a tenant who wants to know your rights, just in case, or maybe you're just curious about how this part of housing law works, this should give you a solid foundation. Okay, so where does it all begin? The eviction process itself.
It always starts with a written notice from the landlord. California law is very clear on this. Before a landlord can legally force a tenant out with a court order, that's the unlawful detainer lawsuit we hear about, they first must give the tenant a proper written California eviction notice.
So it has to be written. Like a landlord can't just say, you need to leave, or send a text.
Nope, doesn't count legally. That written notice, it's not just a technicality. It actually serves a vital function.
Okay, what's that?
It formally tells the tenant the landlord wants them out, why, and crucially, it usually gives the tenant a defined period to either fix the problem if it's something fixable or to move out voluntarily before things escalate to court.
Okay, so it's like an official heads up with a chance to act. What about those nightmare scenarios you sometimes hear about? Landlords changing locks or shutting off power?
Absolutely illegal. Landlords cannot use what we call self-help eviction methods. Things like changing the locks, cutting off your water or electricity, removing your stuff, doing any of that without going through the formal legal process, which starts with that valid California eviction notice, is against the law. Big penalties for the landlord if they try it.
That's really important for people to know. So the California Eviction Notice is step one. I'm guessing there isn't just one kind of notice, though. It probably depends on the situation.
Exactly right. There are several types, and the specific California eviction notice used really depends on why the landlord wants the tenant to leave.
Okay.
Let's start with probably the most common one, the 3-day notice to pay rent or quit.
Okay, the name kind of says it all there. It's about unpaid rent.
Precisely.
Yeah.
Used when a tenant hasn't paid their rent. Now, this notice has to be super specific. It must state the exact amount of rent owed, and it needs to clearly say what time period that rent covers. No guesswork allowed.
And the 3-day part, I remember reading something about court days. Is that different from just 3 regular days?
Yes, critical difference. The notice must state the tenant has 3 court days to pay the full amount or move out. Court days mean business days, weekends, and official court holidays don't count.
Ah, okay. So if you get a notice on a Friday, Saturday, and Sunday, don't count towards those 3 days.
Correct. The clock effectively pauses over the weekend or holiday. It's a detail people can easily miss, thinking they only have 72 hours straight.
Good to clarify. What else absolutely has to be in that 3-day pay rent notice?
It needs to detail how and where the tenant can actually pay the rent. So the days and the times the landlord or their agent is available to receive payment in person and the physical address for that payment.
Okay.
If they accept payment by mail, it needs the full mailing address. If they take bank deposits, it needs the account number, the bank name, and the bank's address.
Yeah.
But only if that branch is within 5 miles of the rental unit.
Wow. 5 miles. That's specific.
Yep. And if there's already an agreed upon way to pay electronically, like through a portal or something, those details need to be there too.
Yeah.
It's all about clarity and making it possible for the tenant to actually pay.
That is incredibly specific. So let's say the tenant gets the notice, scrambles, and pays the full amount within those 3 court days. What happens then? Are they safe?
Generally, yes. If the full rent stated in the notice is paid within that window, the issue is considered cured, and the eviction process based on that notice stops. They get to stay.
Okay.
However, and there's a big happen, however, the landlord might still serve a separate 30, 60, or maybe even a 90-day notice, maybe even at the same time, if they have other unrelated reasons for wanting the tenancy to end later. So paying solves the immediate rent issue, but it's not always a guarantee of staying long-term.
Okay. That's a subtle but important point. So paying the rent might just buy time in some cases.
Yeah.
What's another type of California eviction notice?
The next one is the 3-day notice to cure or quit.
Cure, meaning fix the problem.
Exactly. This is used when a tenant is violating some part of their lease agreement, but it's something that can be fixed. Think having a pet when the lease says no pets, or maybe making too much noise consistently.
Okay, so things that can actually be corrected. What does that notice need to say?
Again, it has to be written, tenant's name, property address, but the key part here is it must describe the specific lease violation very clearly. What exactly is the tenant doing wrong? Then it gives the tenant 3 court days to fix or cure that specific problem or move out.
So using your example, if they find a new home for the unauthorized pet within those 3 court days, they're okay.
Generally, yes. If they cure the violation within the 3 court days, the landlord can't proceed with an eviction based on that specific notice. The problem's been solved.
Okay, that makes sense. So we have paying rent, fixing a problem. What if the violation is really serious? Something that can't just be undone?
That leads us to the 3-day unconditional quit notice.
Unconditional. Sounds final.
It pretty much is. This notice is for serious violations, things that generally can't be cured or fixed. We're talking about illegal activity on the property, causing major damage, creating a substantial and ongoing nuisance, subletting without permission.
Okay, really major stuff.
Right. Or it can also be used under the Tenant Protection Act. If a tenant first got a 3-day notice to cure or quit for a violation, failed to fix it, and then the landlord issues this notice.
And with this one, there's no option to fix it.
Correct. The 3-day unconditional quit notice simply demands the tenant move out within 3 court days. No second chances to remedy the situation mentioned in the notice. They just have to leave.
Wow. Okay, these 3-day notices all seem pretty immediate. What about situations where it's not really the tenant's fault, like the landlord just wants the property back for some reason?
Good question. That's where the 30-day or 60-day notice to vacate comes in. These are often used for no-fault situations where the reason isn't about the tenant doing something wrong. Or sometimes they're used simply to end a month-to-month tenancy.
Okay, and why sometimes 30 days and sometimes 60?
It depends on how long the tenant has lived there continuously. If the tenant has lived in the property for less than 1 year, the landlord generally needs to give a 30-day notice.
Less than a year, 30 days.
Right. If the tenant has lived there for 1 year or more, then the landlord must provide a 60-day notice.
A year or more gets 60 days. Got it. Are there extra rules for these longer notices, especially if it's a no-fault reason, like the landlord wanting to move in?
Yes, definitely.
Yeah.
Especially if the tenant has been there a year or more and the reason falls under specific no-fault just cause categories. These include the owner or a close relative planning to move in, the owner taking the property off the rental market entirely, planning major renovations that require the unit to be empty, or complying with a government order to vacate.
Okay, so those are specific no-fault reasons. What happens then?
In those specific no-fault just cause situations, for tenancies over a year, the landlord has an extra significant obligation. They have to notify the tenant in writing about their right to relocation assistance.
Relocation assistance, what does that mean?
It's typically equal to 1 month of the tenant's current rent. The landlord has to provide this payment within 15 calendar days of serving the notice.
Wow, okay. So some financial help to move.
Exactly. Or, as an alternative, the landlord can choose to waive the tenant's rent for the final month of the tenancy. If they choose the rent waiver, the notice itself must clearly state the amount of rent being waived. It's designed to cushion the blow for tenants being displaced through no fault of their own.
That seems like a really important protection. Are there any cases where a landlord could give a 30 or 60-day notice without one of those specific just causes, even if the tenant's been there over a year?
There were some very limited exceptions, like if the property is a single-family home that's not owned by a corporation or REIT, and the landlord is selling it to a buyer who intends to live there, or certain types of duplexes where the owner lives in the other unit. Also, sometimes housing that's very new, built within the last 15 years, might be exempt. But honestly, these exceptions can get complicated and have their own rules.
It really sounds like the details matter a lot. What about newer leases? I heard something about leases starting after mid-2020.
Yes, that's another layer. For residential leases signed on or after July 1st, 2020 or July 1st, 2022, for mobile homes, if the landlord wants to terminate for a no-fault reason, it's generally only valid if the tenant agrees in writing to the termination.
The tenant has to agree in writing.
Generally, yes. There's a narrow exception for mobile homes if the lease specifically allows the landlord to evict to make it their personal residence. But otherwise, for most newer leases, that tenant agreement is needed for a no-fault termination.
Interesting. Another protection there. And what if the tenant moves out after a 30 or 60-day notice but leaves stuff behind?
Good point. Those 30 and 60-day notices must also include information on how the tenant can reclaim any personal property they leave behind. Landlords have specific legal duties about handling abandoned property.
Okay. And circling back to that just cause thing for tenants over a year, if the Tenant Protection Act applies and it's no fault, the notice has to spell everything out clearly, right?
Absolutely crystal clear. The notice must state the specific no-fault, just cause reason. And it absolutely has to inform the tenant about their right to either that relocation payment or the final month's rent waiver. Transparency is key.
What about that owner move-in reason? If a landlord says they or their family member are moving in, do they actually have to?
Yes, there are rules to prevent abuse. The owner or the specified family member generally must move in within 90 days of the tenant leaving, and they typically have to live there as their primary residence for at least 12 continuous months.
12 months.
Minimum. If they don't meet these requirements, the tenant who is evicted might have legal grounds to sue, maybe even get the unit back. It prevents landlords from just using owner move-in as an excuse when they don't really intend to live there.
That's a strong safeguard. Okay, we've covered 3-day, 30-day, 60-day notices. Is there anything else?
One more main type, the 90-day notice to vacate. This one is specifically for tenants in Section 8 subsidized housing.
90 days for Section 8.
Yeah.
Longer period.
Yes, and importantly, the landlord must have a legally valid reason, a just cause, to issue this notice. They can't just end the tenancy without cause in Section 8 situations.
What does that notice need to include?
It has to detail the specific reasons, the just cause, for the eviction. It must also state that the tenant has the right to fight the eviction in court. And, interestingly, it has to inform the tenant they have 10 days to discuss the notice with the landlord.
10 days to talk? That's different.
It is. It encourages communication before things potentially escalate further in subsidized housing situations.
Okay, that covers the main types. It seems like no matter which California eviction notice it is, there are some things all of them absolutely need to have to be legal.
Yes, definitely. There are essential elements for every single type. First, like we said, it must be in writing. No exceptions.
Got it.
It must include the full correct name or names of all the tenants on the lease or rental agreement.
All 10.
And the full correct address of the rental property. If it's just a room being rented, that needs to be specified too, like room #3 or whatever, identifies the specific space. Accuracy is crucial.
What about telling the tenant what they need to do?
Absolutely essential. The notice has to clearly state exactly what the tenant needs to do. Is it pay rent? How much? Is it fix a problem? What problem? Or is it just move out? And critically, by when? The deadline date must be clear.
And if rent needs to be paid, who gets it?
Right. The notice must list the name, the address, and a phone number for the person who is authorized to receive the rent.
Okay.
And as we discussed with the 3-day rent notice, it has to detail how the rent can be paid in person with days, times, address, by mail, full address, by bank deposit, account number, bank name, address within 5 miles, or by any established electronic method. All the valid options need to be there.
So much detail required. What about proving the notice was actually delivered? You mentioned a proof of service?
Yes, the proof of service is vital. It's usually part of the notice form itself, but it's filled out after the notice is served. The person who delivers the notice, who must be 18 or older and not the landlord themselves, fills it out.
What do they write?
They have to state who they served, how they served it, which specific method, and the exact date and time of service. Then they sign it under penalty of perjury, swearing that the information is true. This completed proof of service is the landlord's evidence that the tenant was legally notified.
So just dropping it in the mail isn't enough. How does it actually have to be delivered legally?
Correct. Just mailing it usually isn't sufficient initially. Proper legal service is critical. There are 3 main ways allowed in California, done by someone 18 plus who isn't a party to the case.
Okay, what's method 1?
Personal service. That's the preferred method. You physically hand a copy of the notice directly to the tenant named on the notice. Simple, direct, hard to dispute.
Makes sense. What if the tenant isn't home or avoids answering the door?
Then the server can try substituted service. This means leaving a copy with another adult at the tenant's home, someone who seems responsible, of suitable age and discretion. Or they can leave it with someone suitable at the tenant's workplace.
Okay, leave it with another adult. Then what?
That's only step 1 of substituted service. Step 2 is crucial. The server must also mail another copy of the notice by first-class mail to the tenant at the rental property address.
Mail a copy too. And does that change the timeline?
Yes. For substituted service, the tenant's clock, those 3, 30, 60 days, whatever, starts ticking the day after the notice is put in the mail, not the day it was left with the other person. That counts for mailing time.
Okay, day after mailing. What's the third option if neither of those work?
The third method is posting and mailings, sometimes called nail and mail. This is usually a last resort, only allowed if both personal and substituted service were tried with due diligence and failed.
Okay, last resort. What does it involve?
It involves securely attaching a copy of the notice to the property in a conspicuous place, like taping it to the front door. And, just like substituted service, you also have to mail another copy by first-class mail to the tenant at that address.
And the timeline.
Same as substituted service.
Yeah.
The tenant's deadline starts the day after the notice is mailed.
Yeah.
Also, it's worth noting, sometimes the landlord might need to get court permission before using posting and mailing.
Wow. Okay. So delivering the California eviction notice correctly is a really big deal. What happens after that notice period runs out? 3 days, 60 days, whatever it is.
If the tenant hasn't done what the notice required, that they haven't paid the rent, fixed the problem, or moved out by the deadline, then the landlord can take the next legal step.
Which is?
Filing an unlawful detainer lawsuit in court. That's the formal eviction case.
And does the landlord need specific paperwork to start that case?
Yes. Especially if it's based on a 3-day notice, the landlord will need the original signed California Eviction Notice with that completed proof of service we talked about. They'll also need a copy of the lease or rental agreement if there is one. These are key documents for the court.
Once the landlord files that lawsuit, how does the tenant find out? Do they get a court date right away?
Not immediately a date, no. The tenant has to be formally served again, this time with court documents. A summons and a complaint.
Summons and complaint, what are those?
The summons is the official court paper telling the tenant they're being sued for eviction. The complaint lays out the landlord's reasons why they believe they have the right to evict.
And what does the tenant need to do?
They need to respond. Typically, under a new law starting January 1st, 2025, tenants will have 10 business days after being served to file a formal written answer with the court. It used to be only 5, so this gives a bit more time.
10 business days to file an answer. What if they don't?
That's really risky. If the tenant doesn't file an answer within the deadline, the landlord can ask the court for a default judgment. That means the court could order the eviction without ever hearing the tenant's side of the story. It can happen fast.
So responding is critical. We talked about just cause earlier. Can we revisit that? It seems really important, especially for longer-term tenants.
Definitely. So in California, if a tenant has lived in a property covered by the Tenant Protection Act for 12 months or more, the landlord generally needs just cause to evict them.
Okay. And what counts as just cause?
It falls into 2 main buckets. First is at fault just cause. This is when the tenant has done something wrong, like not paying rent, violating the lease after a chance to cure it, if applicable, committing waste or a nuisance, criminal activity, things like that. Basically, the reasons covered by the 3-day notices.
Okay, at fault is the tenant's actions. What's the other bucket?
No fault, just cause. This is when the landlord has a specific, legally allowed reason to end the tenancy that's not the tenant's fault, like we discussed. Owner move in, taking the unit off the market, major rehab, government order.
So if you've been there over a year in a covered unit, the landlord can't just say, I want you out, without one of these specific reasons.
That's the core idea of just cause eviction protections.
Yeah.
It prevents arbitrary evictions for longer-term tenants and aims to provide more housing stability.
That's a major protection. Now, we've focused a lot on the legal process. Let's quickly recap what landlords cannot do, these illegal self-help things.
Right. It bears repeating. Landlords absolutely cannot take matters into their own hands outside the court system. No changing locks, no shutting off utilities, water, power, gas, no removing the tenant's belongings to try and force them out.
Those are illegal eviction methods.
Completely illegal. Doing any of that can lead to serious penalties for the landlord, potentially including paying damages to the tenant. The legal process, starting with a proper California eviction notice and potentially leading to an unlawful detainer case, is the only lawful way to evict a tenant.
That's crystal clear. Okay, this has been incredibly detailed. If someone listening actually receives a California eviction notice, it must feel terrifying. What is the absolute #1 piece of advice?
Act immediately. Don't ignore it. Don't wait. Time is really critical with these notices.
Okay, act fast. Where can they turn for help?
There are great resources. Look at groups like StayHoused LA or TenantPowerToolkit.org. The LA County Department of Consumer and Business Affairs has info. For legal help, check lawhelpca.org to find legal aid organizations.
Are there places for people facing homelessness because of this?
Yes, prevention providers like Harbor Interfaith Services or PATH might be able to help, though some programs might require you to have already received, say, a 3-day notice. The main point is, reach out for help right away. Don't try to figure it all out alone or hope it disappears. Understanding your rights and options early is key.
That is excellent practical advice. So as we wrap up this deep dive, what's the main takeaway you want people to remember about the California Eviction Notice?
The biggest thing is that the California Eviction Notice is the mandatory, formal first step in any legal eviction in California. It's not optional. It's required by law. Understanding the type of notice you received, what it specifically requires, the deadline, and knowing that it had to be delivered to you correctly, these are the absolute fundamentals for navigating the situation, whether you're a tenant or a landlord.
A really solid summary. And for you listening, especially if you're a tenant, hopefully this information feels empowering, not alarming. Understanding the California Eviction Notice is really step one in knowing your rights. It seems like the next logical step might be learning more about that unlawful detainer court process and what defenses a tenant might have.
Absolutely. The notice is just the beginning. The court process itself has a whole other set of rules and procedures that are just as important to understand if things get to that stage.
Well, thank you so much for breaking down such a complex topic. It's been incredibly helpful. As always, remember this deep dive gives you a foundation, but every situation is unique. If you are facing an actual eviction notice, getting personalized legal advice is really the best way to go. Thanks for joining us.
Call now 714-442-9741. Thank you.